Welcome to Rebel Chaser. My name is Gail, and I've got a couple new judges for you guys. The first ones are with Judge Dukes in Texas, and then there's a couple more, or no, just one more, with a judge named Judge Villarreal, and then just a short one with Judge West, all in Texas. I'll let you guys watch.
Ma'am, if you'd raise your right hand. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. You put your hand down. Go ahead, Miss Onziri.
So Judge, we filed a non-agreed CSRP for modification. I want court to take judicial notice that Mr. David Cromer was served on February 4th, 2025. And even for the CSRP, he was notified but did not appear. And my understanding is that mom is asking for that order to be granted as entered as it was filed. Let's see. So the CSRP was done back in October of last year. Based on our records, his last quarter back in 2024 income that was reported to us is actually a bit more than what is in the CSRP, the $8,076.66. But Ms. Cromer is still in agreement to base it off of the gross that was pled in our child support review order. Let's see. And I can call Ms. Cromer.
Okay.
Can you state your full name, please?
Daisy Renee Cromer.
Okay. And Ms. Cromer, I went over the child support review order with you, correct?
Yes, ma'am.
Okay. And you are asking the court to enter it as it was filed, correct?
Yes, ma'am, I am. Yes.
Okay. Let's see. Pass this witness.
Anything else from the state?
Nothing from the state.
Okay. Counsel, Ms. Cromer, I'm going to deny the request to confirm the non-agreed child support review order. I'm not going to make a ruling regarding the modification, okay? This was an agreed divorce decree with zero child support. I'm not saying the modification cannot be done, but the way the Attorney General's office has filed it as a non-agreed child support review order, I'm going to deny their request to confirm the non-agreed child support review order. Okay?
Well, I guess I don't completely understand. What do I need to do next to see that this happens?
You may want to talk to the Attorney General's office more or talk to an attorney.
I've been talking to the Attorney General's office since May.
Then maybe you want to talk to an attorney. So I'm going to ask Ms. Zanzir to send over an order denying the request to confirm the non-agreed child support review order. I can't give you any legal advice, ma'am. You may want to talk to an attorney.
Can you just tell me why?
You'll probably need to talk to an attorney to explain that.
I've talked to two attorneys. It's very expensive. And this was 8 years ago that this was filed. And he doesn't even see his children. So he's in violation of the divorce decree anyway.
Okay.
Why would I have waited for one child to age out and one child to be 17?
You're free to go. You can hit the button that says leave or leave meeting. Thank you, ma'am.
All right. Can the Attorney General stay on the line?
Ms. Zanzir, you want to talk to mom a bit?
Yes, I can talk to her.
Okay, ma'am, watch your screen. I'll move you into a room with the attorney. Let me find you again. Give me just a second here. Okay, I've got Ms. Lakey coming back over. Okay, Ms. Lakey, if you'd raise your right hand. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You put your hand down. Okay, go ahead, Ms. Thomas.
Your Honor, we have the pay records in this matter. I would move to admit they have been shared and discussed with Ms. Lackey.
So what is the document that you're wanting to admit?
This is the financial activity report as of March 3rd, 2025 in this case.
And what is it called in your proposed exhibits?
States Exhibits 1.
Would it be 14 Zol FINA?
Yes, Your Honor. Yes, that's correct.
Oh.
That is, sorry.
Okay.
Yes.
That's admitted.
Okay. And according to that document, Your Honor, as
let's back up. Let's back up. We need to talk about Mr. Zoll. He filed an answer. So did the state give him notice?
Your Honor, from the court's docket, it appeared as though that the answer, the notice was returned on or about November the 11th, 2024. However, our documentation also indicates that Mr. Zoll is in the Texas Department of Corrections.
Okay, do you have an exhibit that you would like to enter showing that you gave Dad notice at the address of his answer?
No, I need to get that, Your Honor, if you could give me a second.
Okay.
Judges, can I
Yes.
speak to the exhibit?
Yes, Miss Mason.
Okay, it'll be entitled 14 Zoll NCP notice for 32025.pdf.
Okay, admitted.
Okay, thank you.
Okay, go ahead, Miss Thomas.
Okay, yes, I am trying to find that.
So, Ms. Thomas, what's the state seeking to do today?
Your Honor, we're just going to go ahead and confirm the arrearage amounts for Mr. Zoll. And yes, as far as the notice, that exhibit would be 14 Zoll NCP notice for 32025.
I admitted it already.
Okay, thank you. All right,
So tell me what it is you're seeking to do today.
we're seeking to confirm the arrearage as of the last day of February 2025. And then going forward, as of April 1st, 2025, the child support amounts would be reduced to zero based on the NCP's incarceration.
Okay, go ahead.
Okay, so for the child support amount, that would be $9,656.99. And as for the medical support, that amount would be $3,028.98.
Okay.
And that's all we are requesting of this order, Your Honor.
Okay, go ahead and call your first witness.
Ms. Lackey, do you understand the terms that I have read into the record just now?
The terms for the amounts?
Yes.
Yes, I heard you.
Okay, and I showed you the printout and explained the amounts as of February 25th, February 28th, 2025 to you in our discussions?
Yes.
Yeah, okay. And are you in agreement with these terms?
No to the reducing.
I'm sorry, no to the what?
To the reducing.
Okay, so because you want the child support to continue even though the NCP is incarcerated, correct?
Correct.
But you also understand that you can refile these or seek redress once you understand that the NCP is working and maintaining employment in order to pay for the child support?
I do understand that you told me that, yes.
Okay. Nothing further, Your Honor.
Okay. So, Mom, I know I asked you this a moment ago, but I'm asking you again just to make sure. Do you have any information to give to the court that indicates that Dad has a way to make money right now?
I don't have any information.
Okay. Anything else you want to tell me about why Dad should continue to be ordered to pay child support while he's incarcerated?
I do believe that he should still be, responsible for providing support. And again, as I had spoken with you, I was hoping to have an opportunity to speak with a lawyer to see if there are any other kinds of income that perhaps somebody who's incarcerated could have besides actually working a job, if there's any other streams of income that possibly need to be looked at.
Okay. You did attend when we were here on January 23rd of this year, correct?
Yes, I was here.
Okay. And is it correct that you got served on or about September of 2024?
Yes.
Okay. Okay, so this is what I'm going to order. I'm going to order a judgment as of October the 31st, 2024, based on the state's pay record, child support in the amount of $8,423.54, medical support judgment as of that same date at $2,718.60. No payout based on Dad's incarceration. Dad's child support and medical support are both modified to zero as of November 1st, 2024. I'll waive the court costs based on Dad's incarceration. I'm going to ask Ms. Thomas to draft up that order and send that to me for my signature. Ms. Lakey, you always have the right to appeal my decision, okay? I'm going to sign off on the order when I get it. Then the Attorney General's office will make sure that you get a copy of that. But you always are welcome to appeal my decision, and then the case would start over in the district court like it never happened today, okay?
Okay, thank you.
Okay, thank you, ma'am. You're free to go.
Hello.
Okay, if you'd start your video.
Start my video. I've been pushing buttons up crazy. Here we go.
There you go. Okay, this is number 3. Mom, Dad, if you both would raise your right hand.
Oh, that's my left.
Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you both. You put your hands down. Okay, Mr. Wright, this looks like a modification. What is it that is before the court today?
Your Honor, the state filed a motion to confirm arrears and modify. At this point, Mr. Geist is paid up on his arrears. We're not asking for a confirmation of arrears at this point. The child does turn 18 next month and graduates the following month. So there's only a little bit of modification left to go. However, I think you might get some testimony from the mother that there might still be a reason to go ahead and modify the insurance coverage as well as the child support.
Okay, go ahead.
Oh, go ahead. I'm sorry.
State would call the mother, Ms. McElrath. Ma'am, can you how is insurance currently being provided for their child?
Currently it's my husband, Brian McElrath, that carries Addison.
Okay, I need to know what the current order says, Mr. Wright.
Ma'am, is it correct that the prior order ordered Mr. Geist to carry the insurance?
Yes.
Okay. And you're saying that your husband now provides insurance?
Yes.
Okay. It was my understanding in the breakout room that you wanted your husband's insurance discontinued because anyway, is that correct?
No, not my husband's. No. See, the issue we're having is we've been having denied claims for the past 3 years on.
Okay, so wait.
Okay.
So I just want to make sure we're using the right terms so we know. So we've lost Dad. Give me a second. I think this is him coming back over. Okay, I think Mr. Geist is coming back. Give it just a second here.
Can you hear me?
Yes.
Okay, there we go. I don't know what happened.
It's okay. Okay, so Mr. Wright, the current order says that Dad is ordered to pay cover the health insurance, correct?
That's correct, yes.
Okay, and so Dad, are you wanting to continue to cover the health insurance?
I mean, yes, I would like to just leave things the way they are since she graduates and turns 18 in just a couple months.
And do you currently have health insurance?
Yes, ma'am, through Tyson, through my work. Okay,
very good. Okay, so Mr. Wright, I need to know why I should modify the underlying order regarding health insurance.
So ma'am, are there significant out-of-pocket costs with the current insurance? Ms. McElrath,
Oh, go ahead.
are there significant out-of-pocket costs with the current insurance?
Yes. Can we go back to all the denied claims?
No, I need you to answer his questions.
Okay. Yes, there is. We pay 8110 biweekly.
For what?
No,
For
he's saying, do we pay a lot for?
Okay, sir, I need you to move out of the screen and quit talking. We are in court. So, Mom, his question is the insurance that Dad has, has that caused you significant out-of-pocket expenses?
Yes.
Okay, go ahead, Mr. Wright. Next question.
Okay, can you kind of explain to the court why that has been?
There's been denied claims for past 3 years. And there's also out-of-pocket cost. And I have mailed him bills, but go ahead.
I'm not so much asking about what unreimbursed expenses haven't been paid. That's something that can be addressed in a different motion. What I'm asking is, does the fact that he continues to cover the insurance actually make things more expensive?
We're paying 100% of the bill, of course. Yes.
Okay. And is it because there's this other coverage that your coverage isn't working? Is that what I'm understanding?
No, it's not due to that.
Okay. Again, can you explain then why you don't want him to cover the insurance?
Because he doesn't pay his portion and also the denied claims that I have to sit on the phone for. That's the reason. There were no issues prior to this, before him covering.
Mom, do you know why they're being denied?
No clue.
And
I
so
think
do you
they're
have to fight with,
getting,
do you have
I
to
think,
fight with them to get it covered?
I think what's happening is it's getting filed on Amanda's insurance as primary and his is secondary, and they have to go back, retract it, and then end up filing again on his. Well, they deny it and then they go back and file on his and then go back and file on hers.
And so, but that has nothing to do with him covering the health insurance. That's just something that's happening at the provider's location, correct?
It's not happening at the provider's location. They've actually verified that it is not happening at the clinic. I'm not sure where it's happening.
But it doesn't have anything to do with Dad being ordered to cover health insurance. Correct?
It actually does.
Okay. Okay, go ahead, Mr. Wright.
Is there anything else relevant to this case you want to bring to the court's attention?
I mean, yes, I would. There's been a time I took her for dental work. They filed the claim, and then she was getting ready to have her wisdom teeth removed, and I went back because we weren't supposed to come up with anything. And then I was out of pocket like $500 and something right then and there. She had to have it. She had to have the surgery. So they went and used the benefits prior to her surgery. So yes,
Went and used the benefits.
the dental benefits,
Who went and used them, you said?
whoever's on their medical plan. But when we arrived, we had to pay $500 and something for her wisdom teeth to be removed.
Okay. And do you have a secondary plan?
Just primary. My husband.
And does it cover
No,
dental or
as
no?
ordered, it's for Dad.
I know,
I'm sorry?
but I'm saying, do you have a secondary plan?
No.
Okay. Okay, go ahead, Mr. Wright.
I'll pass this witness.
Okay.
State will call the father, Mr. Geist.
Yes, sir.
Sir, are you asking that the insurance coverage remain the same as currently ordered?
Yes, sir.
And do you believe that's in the best interest of the child?
Yes, sir, I do. Just to throw something out there.
Hold on, Dad.
Okay.
Let him ask a question.
Okay. Yes, ma'am.
And why is that?
Because all of my insurance claims all have co-pays.
What do you mean by that?
That means it's a $35 deductible for every time she goes to the hospital or to the doctor, depending on which kind of doctor she goes to.
According to your last year's taxes, did you make an average of $2,865 per month?
Correct.
And if the court were to modify child support today, are you in agreement for a modification to $443 per month beginning next
Correct.
month? Okay. Is there anything else you want to bring to this court's attention?
I mean, she has multiple insurance plans, and the mother hasn't used either one of them. So, she hasn't used either one of them properly. I mean, the doctor bills they're not getting filed in order. So, and that's kind of where we're at with the insurance part.
I'll pass the witness.
Counsel, what was the previous child support amount?
Sorry, that's something different. $380 per month.
Okay, I'm going to modify the current child support to $443 beginning April 1st, 2025. I'm going to deny the request to modify the medical support order. Dad to pay court costs within 1 year if billed by Collin County. Mom, Dad, I'll ask Mr. Wright to send me the order. Once I sign off on it, the Attorney General's office will send you both a copy. If you don't agree with my ruling, you both are welcome to appeal my decision. Thank you both. Yes.
Actually, there's one issue I did forget to address. There was a non-disclosure ordered in the prior order. I believe parties are in agreement to continue that.
Okay. And Mr. Wright, the motion that you filed was a modification only. There was no confirmation of arrears, so no need to. Okay, we've got Mom back, just waiting on Dad's device to come back. There it is. Okay, we've got both parties back on 14. Mom, Dad, if you both would raise your right hand. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you both. You put your hands down. Go ahead, counsel.
Thank you, Your Honor. We have an agreement, and the parties are in agreement for us to move forward with a trial amendment to add conservatorship and possession and access, which was not previously pled for by the state.
Okay.
They would like the court to take judicial notice that Ms. Papoka and Mr. Whiteside are present in the courtroom today.
Okay.
Parties are in agreement that there are 2 children at this case, and that the father, Mr. Whiteside, has 2 other minor children. The children are currently on Mr. Whiteside's medical insurance through his employer, which he pays $212.48 for health insurance a month and $60 for dental insurance a month. The father's gross income, as reported by his employer for the first quarter of 2025, is $4,700.58, with a net income of $3,674.32. Parties are in agreement for the guideline support to be set at $758 a month beginning May 1st, 2025. Parties are also in agreement for the father to continue carrying the health and dental insurance as he's been doing. There's no retroactive child support arrears granted, no finding of family violence in the last 2 years. Parties are in agreement for the mother's request for a non-disclosure of her address. And parties are in agreement to an exchange location at the dependent's grandmother's house, Miss Maria Fernandez. Address Link Street, Red Oak 75154, or at the Walmart in Red Oak, address 100 South Ryan Drive, Red Oak, Texas 75154.
Counsel, is this a non-disclosure based on a third party?
Yes.
Okay, just make sure the wording in the order says that it's not if it's been a third party, why are we doing, I guess I don't even know what the visitation is. So we'll keep going and maybe I can figure it out. Keep going.
It is the state's understanding that Ms. Papoka is involved in a new relationship, and to ensure that peaceful existence between the non-custodial father and her new partner.
Okay, so what's the visitation? I don't even know what custody is. So let's start there. Give me custody and visitation, then I can maybe ask some more questions.
Thank you, Your Honor. And that will probably explain things. According to Mr. Papoka and Mr. Whiteside, Ms. Papoka's current partner is who the children believe are their father. So the parties are in agreement to wait to begin visitation till May 26, 2025, when the children finish STAR testing and final exam, to give the mother an opportunity to explain that Mr. Whiteside is their family without creating emotional upheaval prior to testing. There will be a phase 1 for 1 month where the children have visitation first and third Saturdays from 1 p.m. to 6 p.m., supervised by the grandmother, Maria Fernandez. Upon completion of phase 1, there will be a phase 2 for 1 month of an overnight visitation, unsupervised.
Hold on, I've got confused. So the first and third Saturdays, 1 to 6, what Saturdays are those? I mean, the first, and how many of those are there?
In the month of June, there's 4.
Okay, so we need to do a number just in case they get off or they miss or they doesn't work out. So he'll do 4 visits, 1 to 6 on first, third Saturdays, or is
Yes.
it every Saturday?
The mother actually was in agreement to begin May 31st, so we can begin the first visitation on May 31st, which is a Saturday.
Okay.
And then the second visitation, June 14th.
That's the second, not the first or third.
Yes, you're right.
So, okay, so if we do first, third, let's say first, third, and fifth Saturdays beginning May 31st. So that'll be 3. So it's 3 to get to the end of June. So what were y'all thinking?
We can do May 31st.
Because that's the 5th.
That is the 5th. Okay, then perhaps we should start June 1st, which is the beginning of the month, the 1st. And then the 3rd would be June 21st, Your Honor.
Okay, so how many of those are we doing in step 1?
So then that's 2, June 7th and 21st.
So just 2 visits.
Mm-hmm.
Okay. And then, I'm sorry, step 2 is what?
Would be an overnight, Saturday 6 p.m. to Sunday 6 p.m.
And when are those?
That would be July 5th and July 19th.
Okay, we need to know, okay, so they're going to be the first and third Saturdays?
Yes, Your Honor.
And he'll do 2 of those?
Yes, Your Honor.
2, okay. Okay, go ahead.
And then the third phase is just the state standard possession.
For parties that live how far apart?
For parties that live less than 50 miles.
Okay, so at that point, most of the visits, pick up and drop off, are at the child's school. Right?
I'll take testimony.
No, I'm sorry, because it's 50 to 100. No, less than 50. So yeah, so it would be at the child's school, most of the pickup and drop offs. If that works for Dad.
Summertime, but I will ask the mother during testimony because it will be during summer.
Okay.
I'll take testimony to that.
Okay.
And then court costs are billed to the father with a year to pay the court costs.
Okay. I don't know about conservatorship still.
I'm sorry. Parties are in agreement to be named joint managing conservators and with a geographic restriction for the mother to the Ellis and surrounding counties.
Okay.
Ms. Paprika, can you please state your full name?
Margarita Popoka.
Can you please state the name and ages of your children?
Amelia Whiteside, 12 years. Jerome Whiteside, 10.
Ma'am, did you hear the agreements that I read?
Yes.
And are they still your agreements?
Yes.
And do you believe they're in the best interest of your children?
Yes.
Okay, before we conclude, I just need to clarify a few things before we proceed, okay?
Yes.
The dates, June 7th and June 21st for the first phase of the visitations, are you in agreement with that?
Yes.
Okay, and for the second phase, the overnights, July 5th and July 19th, are you in agreement with that?
Yes.
And when Mr. Whiteside begins the state standard possession, are you in agreement for drop off and pickup at the children's school?
Yes.
And just so we clarify for the judge, your request for non-disclosure was not from any acts of family violence that occurred in the last 2 years.
No.
It's just that you want your address to be private.
Yes.
Okay. Do you have any safety concerns with Mr. Whiteside?
Um, honestly, not him,
Okay.
but I'm just concerned about his family.
Okay. Okay. His family, safety towards you, that is.
Towards the kids.
Towards the kid. Has there been any acts of family violence towards the kids?
He just has an uncle that I don't feel that was in prison for numerous years, and I don't feel safe with the kids around him.
Okay. Miss Paprika, does Mr. Whiteside live with said uncle?
No, but he does go a lot to his grandma's house, and his uncle lives with his grandma's house, I think, still.
Okay. So, I guess you're asking when he has possession, maybe for the kids not to go to the grandma's house?
Well, as long as if the uncle's there, then yes.
Okay. Okay.
Mom, what's your problem with the uncle?
The one time that Mr. Whiteside had the children with him around the uncle's house, he called me. I was just down the street when I had left, telling me to call the police and to tell him to go to the house because he was in a fight with his uncle. And then when I went to try to get the kids, get them out, make sure they were okay, his uncle got in my face and started saying.
So Mr. Whiteside recognized that this was not a good place for the children and asked you to come help out?
Yes, but
Okay.
when I got there, there was nobody out there to let me know what happened. To this day, I honestly don't know what happened in that situation. I just
Okay.
knew that I had to go do what Mr. Whiteside asked me to do.
Okay, that's fine. Okay, go ahead, Miss Edgerfung.
Okay. And are you asking the court to accept the agreements we reached today?
Yes.
I pass the witness, Your Honor.
Okay.
Mr. Whiteside, can you please state your full name?
I'm Jeremy Whiteside.
Excuse me, do you mind if I take this call? It's my daughter's school.
Go ahead.
Thank you.
We'll go off the record for just a moment.
Thank you. Thank you, Your Honor. Mr. Whiteside, are you ready to proceed or do you need some more time?
No, ma'am, I'm ready.
Okay. Sir, did you hear the agreements that I just read?
Yes, ma'am.
And are they still your agreements?
Yes, ma'am.
And do you believe they're in the best interests of your children?
Yes, ma'am.
Okay. And just so the court's aware, you are in agreement to wait till June 7th to begin the possession and access. Is that correct?
Yes, ma'am.
Because you're agreeing to allow the mother an opportunity to explain to the children about who their father is and what's going to take place going on.
Yes, ma'am.
Okay. Are you asking the court to accept these agreements today?
Yes, ma'am.
Okay. And you're in agreement to pay court costs and to take a year if needed to pay the court costs?
Yes, ma'am.
Okay. Your Honor, the state rests and I pass the witness.
Right. I am going to grant the trial amendment to include the agreements of the parties that they will be joint managing conservators. Mom will have the right to designate the primary residence of the children between Ellis and any contiguous counties as long as dad lives in one of those counties. Visitation as set out by Ms. Edgerfung and agreed to by the parties in 3 steps. The exchange on the first 2 steps will either be at the grandmother's house or at the Walmart as agreed to by the parties, or any other place the parties agree to. But council will put the locations that you guys have discussed in the order. That'll be for the first 2 steps. Once dad reaches the third step, which is standard visitation for parties that live within 50 miles, dad will pick up and drop off at the school when the children are in the school time. But when they're not at school, they will pick up and drop off at mom's home or any other place the parties agree to. There'll be no non-disclosure. Child support 758 will begin May 1st. Dad will cover the health insurance. No retroactive support. Dad to pay court costs within 1 year if billed by Ellis County. No other restrictions on the visitation. Counsel, does that hit all the issues?
And parties to be joint managing conservators?
Yes.
Thank you.
Mom, Dad, I'm going to ask counsel to draft that up and send it to me. Once I sign off on it, the Attorney General's office will send you both a copy.
David Enrique Garza Ornelas versus Pamela Garza Vaca, cause number 2023 FLA 120333. Court marks Ms. Morales, present in person. Are you David Enrique Garza Ornelas?
Yes, afternoon.
Welcome to court, Mr. Garza Ornelas. Court marks you present in person. The person to your left is your lawyer. Good afternoon, Ms. Soto. One more time. Good afternoon, Ms. Soto.
Good afternoon. Can you hear me, Your Honor?
You're coming in spotty, but yes, we can hear you now. Court marks you present. You're participating by video conference. Good afternoon, Mr. Vela.
Good afternoon, Judge.
Court marks you present. Both you and Ms. Soto are participating by video conference. Pamela Garza Vaca, are you present? Court marks Ms. Vaca not present in person, not present by video conference. Is anybody here on behalf of the Attorney General's office? So noted. Ms. Morales, Ms. Soto, what is the announcement?
There's several motions, Your Honor, that are present before the court. I think that maybe perhaps the court would want to take Ms. Eli Soto's motion to withdraw from this case.
I reviewed the procedural history. I think what the court would like to do is hear the motion to withdraw and then hear the reconsideration of the motion to transfer. Any objection to that order, Ms. Morales?
No, Your Honor.
Any objection to that order, Ms. Soto? One more time.
No, Your Honor.
Any objection, Mr. Vela?
No, Judge.
All right, Ms. Soto, your motion to withdraw, go ahead.
Your Honor, I did file that motion after the last time we were in court. I have been unable to communicate with my client. I have made several attempts through email, telephone, WhatsApp messages, text messages, all of which have come back unanswered. So because I have been able to communicate with her, I did file my motion to withdraw on this matter. And she was advised of today's hearing via email.
Any response or objection, Ms. Morales?
No, Your Honor. I mean, there's no way that she can adequately represent her client if she's not able to communicate with her.
Any response or objection, Mr. Vela?
No, Judge.
I guess before the court considers, Ms. Soto, besides, maybe obvious, I just need to put it on the record, but given the lack of communication, do you have any idea where the children are or how they're doing?
I've asked that, Your Honor. The last time I spoke to my client was maybe a few days before our last court setting. At that time, they were in Monterrey with my client. After that, like I mentioned, I had no communication with her. So this present time, no, I do not know her whereabouts or the children's whereabouts.
The court has considered counsel's request to withdraw, given the contents of the motion, given the representation of counsel, given the non-objection. The court hereby finds that there is good cause to grant the request. The request is hereby granted. Court has received, reviewed, and considered an order allowing the withdrawal. It is signed. It is so ordered. You're withdrawn, Ms. Soto.
Thank you, Your Honor.
Your Honor, does the motion or order contain the last known email address?
It does. It does contain it.
Thank you.
That's a great question. Thank you. All right. Now, there was either a motion to rehear or the court had advised all parties that the court was going to reconsider the motion to transfer venue. So that was definitely stated in open court and on the record. Ms. Morales.
Yes, Your Honor, and I am taking the opposite position that I took back last year. In this case, I have submitted to the court pursuant to section 152.207 of the Texas Family Code, information to the court to consider in retaining jurisdiction of this court. If in that section of the law, Your Honor, there are 8 factors that the court should consider at any time. The court can at any time consider that proposition of declining jurisdiction based on a forum nonconvenience. However, those 8 factors that are listed there, we have in my information to the court, I have gone through each one of them. And at this time, if the court would recall, I took over this case in December of 2023. There were no temporary orders. We asked for temporary orders. We got temporary orders. There were some problems with them, but overall, we pushed through it and we thought we were doing good. He was seeing his children. Sometimes she would refuse to bring him to Laredo, no problem. He would go and visit them in Monterrey. If the court would recall, at the time that I filed my motion, hardly any discovery had been ongoing. The ad litem had not been appointed. So after the court denied that motion, my motion, and really that the respondent filed a very good brief saying this court has jurisdiction. I want you to stay with this. I am submitting to this court's jurisdiction. She even filed an answer and a counter petition, which she refused to, even if the court would have granted mine, she wasn't going to withdraw her counter petition for divorce and custody. And so we pressed on after that, Your Honor, did extensive discovery. I mean, there's literally about 1,000 documents. And the ad litem got involved, got to talk, I believe, to at least to my client and to the kids. If the court would recall, in July of 2024, so basically she objected, and that was in April.
I recall all of that. So the court's question is, at the time, I think, so let's move on. So at this juncture, as of April 22nd, 2025, what is Mr. Garza Ornella's position? Does he object or agree with the request to transfer?
He objects. He wants the case to stay here at this juncture. Your Honor, all the discovery that has been done, and that's one of the factors that are outlined in section 152.207.
The court has jurisdiction now. The court has jurisdiction now and had already made a decision. But I guess going forward, if Ms. Garza Baca is unresponsive, what could the court possibly do to grant the parties any relief, let alone that make any decisions in the best interest of the children that would be complied with?
Well, one of the things, Your Honor, that my client has done, and it's in my position paper, is that he has been in constant contact with the State Department. And the State Department basically says, when you get a final order from this court, we are ready as the State Department. And I believe I keep forgetting the name of the organization, Your Honor, but it's under the Hague Convention, but it is the children.
Well, if nobody's here to urge the motion, I guess let me just get confirmation. Mr. Bella, do you, on behalf of your clients, have any position on the motion to transfer?
No, Judge, I would request the court retain jurisdiction and deny the transfer at this moment because the court acquired jurisdiction over all parties and entered orders. And for some reason, the respondent is not here. So I feel the court should retain its power over the case and the parties.
Well, and so there's the reconsideration. The court was going to reconsider based on whatever evidence, testimony, and information you brought to the court. At this juncture, nothing has been presented to the court, number one, and number two, nobody's urging it, and both of you oppose it. So, all right, the request to transfer is once again denied. All right.
Thank you, Your Honor. I think that is in the best interest of the children. Their doctors are here, everything is here. And that's one of the main points in that section of the law. Where is the evidence located for the court to dispose of a case?
Okay, so that being the case, what is left pending for the court to consider today?
Your Honor, today we have a motion for motion to compel. This is our third motion to compel discovery. And in my motion, basically, I said she has not provided any financial records. She provided some, but not a complete set of financial records, bank accounts. Certainly did not provide information on the real estate that she owns, and she does own real estate. We were able to get and have submitted all of these documents, Your Honors, have been submitted to the opposing counsel in discovery. All of them are already in the system. We've already submitted all that, but she has not submitted some of the documents that relate to what happened to that contract. It was like a contract for deed. Our suspicion is that she already finished paying for it, and that's why she's not submitting anything, because it would be considered community property. And mainly those are the things that have not been submitted. She did submit some of the medical psychological evaluations after the motion was filed. So we have that. But basically, we're asking the court to order her to answer, to supplement a response to request for production number 5, number 6, number 7, number 8, number 9, number 10, number 11, number 14, and number 15, 16, 17, 19, and 20, 22, 25, 27. So basically, all she keeps saying is, we'll supplement, we'll supplement, we'll supplement. And if the court would recall, you sent us to mediation, and a lot of those documents are important for our case. So in my motion, I'm asking that the court sign an order compelling her to answer, giving her a week to answer. And I am asking that the court award us attorney's fees, Your Honor, because we have had to come before this court 3 times already.
Right, Ms. Morales, would you raise your right hand?
Yes.
You solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Right, yeah, tell the court anything you want on fees.
Yes, Your Honor. My name is Maria Elena Morales. I've been a licensed attorney since 1978 and mainly have practiced for the last 45 years in the area of family law. Very familiar with what is reasonable attorney's fees in this locality. I actually charge $250 an hour. And in connection with this motions, Your Honor, to compel and everything that I have done, I am requesting that the court award the sum of $1,500 to be charged against Ms. Garza Baca.
Anything to add, object to, or in cross, Mr. Vela?
Nothing to add, Judge.
All right, in cause number 2023 FLA 1203C3, the court has heard the third motion to compel discovery, and for sanctions, the court agrees with counsel having taken judicial notice of the entire case file, including that motion, any responses thereto or lack thereof. The court finds that Mr. Garza Ornelas is entitled to the relief he is requesting. All of those stated on the record are hereby due on or before April 30th. At 5 p.m. to the offices of Maria Elena Morales. The court finds that it was necessary for counsel to file this request as there have been no answers. Given the testimony of counsel, the court finds that $250 per hour is reasonable and necessary in this case, and in conformity with the rates paid in this jurisdiction. The court finds that $1,500 is reasonable and necessary. It is hereby granted. Those all of that is due April 30th by 5, and then we'll come back for final hearing May the 6th at 2 p.m. Do you have a proposed order?
No, Your Honor.
Get it on file in a day or two.
Get it on file today. I have it.
All right. Anything else for the court to consider on this case, Ms. Morales?
I don't think so, Your Honor. I think those were the three matters that were set before the court.
I think you're right. Mr. Vela, anything else for the court to consider?
Judge, I would just ask if the clerk can send a copy of the order granting the motion to withdraw and the trial setting to Ms. Garza's last known email address.
Will the clerk, court, or coordinator do that, please?
Yes, Your Honor.
All right.
Will do that.
All right, Mr. Rafamelas, I wish you and everyone well. Good luck to you. We'll see you very soon.
Your Honor, will the final hearing be held in person on hybrid? We also have a witness in the virtual wall of the courtroom.
Lawyer in Mexico.
Yes, Your Honor, I had an attorney from Mexico if necessary to testify if if we were going to go into why we couldn't file at this time in Mexico.
Well, I mean, so Ms. Garza Baca has been appearing online, so I'm going to continue to make this hybrid so that if she does want to appear, or anybody wants to appear, I guess they can. And I think that was the court's initial considerations at the time the first request to transfer was made. And I said, it doesn't matter if people are in different places, as long as they can testify by Zoom and nobody objects, then it's allowed. So I'll continue to allow it. All right.
Just wanted the court to take into consideration the time allotted to the final hearing, since she is a Spanish speaker.
Right. All right. Good luck to all.
Melissa Taylor. Good morning. Are you Melissa Taylor?
Yes, ma'am.
What do you have on your...
Oh, this is my son, Brandon Taylor.
Uh-huh. Why'd you wear that this morning?
Because he's my entire world and he's messing me down.
Okay. Miss Taylor, this is your initial... No, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted the 4 different attorneys. I have the printout paperwork. I got all the information. They're extremely expensive. I'm not going to get the funds gathered for that.
Who'd you talk to?
I spoke to, I had it down.
Where?
Come up to
Where'd you?
wrap it in my phone.
Okay. Did you talk to some more since that last court date?
The last hearings.
Uh-huh.
You asked, you instructed me to get 3 quotes.
Mm-hmm.
That was what I did. I can get that turned into you after.
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. We're going to text.
My belongings.
Just have a seat in the jury box like I told you. Miss Taylor. Miss Taylor, you tested positive for amphetamines, methamphetamines, and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions. And I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer. The other, credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case. If you make the bonds in those cases, you are ordered to wear a drug patch at all times, get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question, please?
Mm-hmm.
Am I about to be arrested?
Yeah, you're going into custody right now.
Okay. I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So
go back with the bailiff right now. Go back with the bailiff. Go with the bailiff.
My child is missing, and he's with a terrible person. He's the only thing that
Yeah. Good morning, Mr. Lewis.
Good morning.
How are you today? Good. I've got two in the back, so we're just going to wait a minute and hopefully that'll be it. We'll see. Good morning.
Well, I hope you guys like those new judges. I thought they were both pretty good. Tomorrow, I get to go to jury duty again. It was less than a year ago that I had to go before, and I get to go again. So I don't know, I will probably be excused because once they find out I have a YouTube channel that shows court cases, they no longer want me. So I will probably be removed, but I probably wouldn't get out of there till afternoon. And I don't know what I'll be able to find at that point in time because by the time, I'm on Pacific time. So by the time I get out and it's noon, it's 3 o'clock back east for Michigan and all of those guys. It's 2 o'clock in Texas. So I don't really know what I'll be able to get, but I will try. If not, I'll see if I can find some old piece that I've been saving. So thank you guys so much for watching, and I'll see you next time.